You know, in our legal system, some cases just need an expressway to get to justice. Well, that's exactly what a summary trial is designed to be, a fast-track process for minor offenses. So let's break down exactly how it works.
We've all heard the stories, right? Minor cases getting stuck in the court system for years and years. It creates this massive traffic jam of justice. But does it have to be this way? Is this long wait really necessary for every single offense?
Well, the answer to that traffic jam is the summary trial. It's a speedy judicial process specifically designed for petty offenses. The entire procedure is laid out in our Criminal Procedure Rulebook, the Bharatiya Nagarik Suraksha Sanhita, or BNSS, specifically in sections 283 to 288. Okay, so here's our roadmap. We're going to look at the traffic jam problem, then dive into the expressway solution. We'll find out who gets to run these trials, which offenses are included, what the procedure and punishments look like, and finally, we'll wrap up with the key takeaways. Let's get started. The core problem is perfectly captured in that old saying, justice delayed is justice denied. A slow, complicated judicial process doesn't just postpone justice. It can actually undermine the very idea of justice for everyone involved. And this is exactly where the summary trial steps in as the solution. It's a streamlined process that cuts through a lot of the unnecessary formalities to deliver swift justice. It gives magistrates the discretion to identify eligible cases and put them on this fast track, avoiding the lengthy procedures of a regular trial. So who gets to be the traffic controller on this judicial expressway? Let's take a look at who actually has the power to conduct a summary trial. The power structure is pretty clear. Under Section 283 of the BNSS, the primary authority rests with the Chief Judicial Magistrate, or CJM, and Judicial Magistrates of the First Class, or JMFCs. But Section 284 also allows the High Court to empower a second-class magistrate to conduct these trials, though usually for even more minor offenses. Now, obviously, not every case can take this express route. There are specific rules of the road, or rather, a clear list of offenses that are eligible for a summary trial. Let's see what they are. Section 283 spells out exactly which cases qualify. We're talking about things like petty theft, possessing stolen property, insults intended to provoke a fight, or criminal intimidation. The law also includes attempting to commit these offenses or abetting them, as well as offenses under the Cattle Trespass Act. Now, for theft-related offenses, there's a really important condition. For a case to be eligible for a summary trial, the value of the stolen property cannot exceed 20,000 rupees. This financial cap is crucial for making sure that only genuinely minor cases are put on this fast track. And this brings us to a key legal principle established by the case of Balwant Singh versus Emperor. The court's ruling was simple. If an offense is not explicitly mentioned in the list under Section 283, it cannot be tried summarily. That list is final. Another critical limitation comes from the case of Mulal versus Emperor. This ruling prevents a magistrate from reclassifying a serious offense as a minor one just to fit it into the summary trial procedure. You can't bend the rules just to use the shortcut. The nature of the crime must genuinely fit the criteria. All right, so now that we know who can conduct a summary trial and for what crimes, let's get into the nuts and bolts. How does the process actually work, and what are the limits on the punishment that can be given? According to Section 285, a summary trial follows the same basic steps as a regular summons case trial, but everything is abbreviated. A summons case can be detailed and take a long time, but a summary trial is designed for speed. The evidence is summarized, the judgment is brief, and most importantly, the potential punishment is much lower. So here's the bottom line. Under Section 285, subsection 2, the absolute maximum punishment that can be handed down in any summary trial is imprisonment for a term not exceeding 3 months. It's a hard limit, ensuring this fast-track process is reserved only for less serious cases. Now, just because the trial is summary, it doesn't mean it's undocumented. Not at all. Section 286 is very strict about this. The magistrate has to maintain a detailed record for every case with these 10 specific points. Everything from the case serial number and date of offense to the accused's plea, the final finding, the sentence, and the date the proceedings terminated. Sections 287 and 288 lay down the rules for the final judgment. If the accused pleads not guilty, the magistrate must record the substance of the evidence and the reasons for their decision.
Case law has further reinforced procedural sanctity. The case of Shrunder Singh versus State of UP established that the magistrate's full signature is required, not just initials. And Abdullah Aziz versus State made it clear that using a rubber stamp instead of an actual signature is illegal.
Okay, we've covered a lot of ground, so let's boil it all down to the most critical points you need to remember, especially for any exam. Here are the essentials. The purpose of a summary trial is swift justice in minor cases. The key governing laws are sections 283 to 288 of the BNSS. The power to conduct them lies with the CJM, JMFC, and specially authorized second-class magistrates. The absolute maximum punishment is 3 months imprisonment. And finally, a detailed 10-point record under section 286 is mandatory. And that brings us to our final thought. The summary trial is an essential tool for efficiency, a way to clear the traffic jam in our justice system. But it also raises a fundamental question. In our quest to speed up justice, do we risk compromising its quality? That's something to think about. Thanks for watching.